July 7th, July 4th tie.
Thank you.
Very nice. Has bursts of fireworks. July 7th, July 4th tie.
Thank you.
Very nice. Has bursts of fireworks. Very nice.
Let's hope we don't have that in the courtroom, Your Honor.
Very good. Mr. Wadinski is present on behalf of the plaintiff. Other appearances?
Oh, we're here. The defendant.
Mr. Patrick Murray. Very good.
Mr. Murray.
No, Patrick is.
Mr. Murray's been
Oh, this is the cider glance. Eric cider glance.
Right.
Very good. And the matters before the court for a non-jury trial.
That is correct.
Is the plaintiff ready?
Yes, Your Honor.
And are the defendants ready?
No, Your Honor. Respectfully, we have taken counsel with former Deputy City Attorney Benjamin Carabian as of this morning. He was on a trip until yesterday, and he only got back to us this morning, and he told us to kindly let you know that he would be our attorney, and he gave us his bar number and approval. We have it recorded, and he'll authorize us to send it to you if you requested for us hiring him, and he would like time to catch up on the case. He had already been aware of it, but he's taken a hiatus for 6 months from talking to us about it, because it was a conflict of interest at the time, because he didn't want to be involved in something he could be in trouble for until he knew whether or not we were going to pay him. And so that's not the point. He said he's available in late August and can get back to you immediately, but he's in trial at LAX Airport this morning.
Are you making a request to continue the case?
Yes, we're making an oral motion to retain counsel.
All right, that request
which we have obtained.
That request is denied. You've waited too long, and the matter is here for trial today. Your request to continue is denied.
We have one other thing to bring up, Your Honor.
Please go ahead.
The trial notebook is not prepared at the moment, but that's due to us receiving a virus from the last summary notes from court from the plaintiff's lawyer. We have proof from a virus repair shop that shows the file that was sent to us, specifically the PDF that was sent to us, gave us a virus, and that our operating system was destroyed and all of our files were corrupted. We only had some of our files ready to use, and we haven't been able to get them back from the virus protection place and hard drive recovery specialist, Mac specialist that we used, and but it's only like in the last 24 hours, and we're still getting our computer up and running properly, because we spent over like $500 just getting this repaired. We are ready, though. Basically, it would just take us another 24 hours to provide that.
Your request to continue on those grounds is denied. We're going to start the trial.
We also put in, Your Honor.
Go ahead, sir.
We also had put in a demand for jury trial over 2 weeks ago, and also 3 months ago. You didn't notice them, and you also didn't see where they were in the court filings, but we request you please relook and see that we did actually file a request for trial by jury, a demand for trial by jury. It's really imperative that we aren't, short-sighted of that.
Mr. Linsky.
Your Honor, this matter was sent out from Judge Colrott as a bench trial to the Chatsworth Court. It was then returned at that point in time. I don't believe the defendants get the right to then, after the case being sent out by a bench officer as a bench trial, to then make a demand for a jury trial thereafter.
Mr. Seidenglantz, your request for a jury trial is denied. It's untimely.
Excuse me.
Ma'am, your name?
Hi, my name is Elizabeth Seidenglantz.
Yes, Ms. Seidenglantz.
The reason why we're not at court trial there at present, despite having
we request you.
By a bench officer is a bench trial. By a bench
Request for
the court should have given them a continuance.
Are you ready to proceed?
We're ready to proceed.
Has gone into our
Excited of that.
Mr. Linsky.
Your Honor, this matter was sent out from Judge Colross as a bench trial to the Chatsworth Court. It was then returned at that point in time. I don't believe defendants get the right to then, after the case being sent out by a bench officer as a bench trial, to then make a demand for a jury trial thereafter.
Mr. Seidenglantz, your request for a jury trial is denied. It's untimely.
excuse me,
Ma'am, your name? Ma'am, your name?
hi, my name is Elizabeth Seidenglantz.
Yes, Ms. Seidenglantz.
The reason why we're not at court trial there present, despite having agreed to that last time, is because we're constantly with the threat of someone breaking in and to perform a lockout. And I just have been, someone has just has gone into our house now, and Eric's going to inquire about it. It's actually really stressful, and I can provide you proof from a video showing that this is the case.
Thank you, Ms. Seidenglantz. Ms. Seidenglantz, your request to continue on the basis of your fear of a lockout is respectfully considered and denied. All three of your motions to continue are denied. I deem you ready over your objection. We're starting the trial today. What time can you be ready?
Whenever the court has the availability, Your Honor.
We're going to start the trial this morning. Will you be calling in or will you be here in person, Mr. and Mrs. Seidenglantz?
I have to call in, I'm sorry.
All right. Well, please stand by. We're going to start the trial this morning. Please stand by. We're going to start the trial. You ready to recall number 3?
Yes, Your Honor, that's Cheney Shapiro versus Patrick Murray, 20 ST 02800.
Good morning. Appearances, please.
Good morning, Your Honor. Peter Wadinsky, the plaintiff.
Thank you, Mr. Winsky. And Eric and Alicia Seidenglantz, are you on the line? They've hung up.
I haven't heard from them since the last time we spoke with them.
Have you had any contact with the defendants?
We've received a series of emails, Your Honor, during the period of time, begging us to give them a continuance, essentially, and explain to us over and over again why they think the court should have given them a continuance.
Are you ready to proceed?
We're ready to proceed.
I'm going to call the other matter and then start this court trial in just a moment.
Thank you, Your Honor.
Let's recall.
Cheney Shapiro versus Patrick Murray, 20 ST 02828.
Appearances, please.
Good morning again, Your Honor. Peter Wadinsky, the plaintiff.
Thank you. Have we heard from the Seidenglantz? Eric Christopher Seidenglantz and Alicia Seidenglantz? Right, they were on the phone earlier. Did they call back?
I'm not aware of your wait, hold on. There it is.
Eric Seidenglantz, Alicia Seidenglantz, can you hear me?
Hi. Hi, can you hear me?
Yes. Are you Miss Alicia Seidenglantz?
Okay. Hi. Yes, Eric and Elizabeth here.
Very good. The matter is before the court for trial. We're about to start the court trial. Will you be attending remotely or will you be coming into court?
Oh, I'm coming. Rough audio from you guys. One second. Hello?
Hi, this is Judge George Bird. Can you hear me?
Yes, we can hear you now.
Very good. we're about to start the trial. Will you be attending the trial in person, or will you be attending virtually by telephone?
We are forced to stay here virtually as our house has literally been attempted to be breached while we were here on the phone with you earlier.
How was your house breached while you were on the phone?
A person downstairs tried to break into the lower unit of our property inside of our building, and I was forced to go down there and deal with it and call the police.
All right.
This is the fourth or fifth time.
Yes, and it's,
All right, well, we're here for trial now. We're about to start the trial. Mr. Wininski, are you ready?
Yes, Your Honor.
All right. I'll hear from the plaintiff for an opening statement.
Thank you, Your Honor. In this matter, my client purchased the property from Cheney Shapiro, who had purchased the property from the bank. When the bank sold the property to Ms. Shapiro, she investigated the property and found it to be in dilapidated shape and appeared to have nobody living in the property. When she came back later, she learned that the property appeared to be occupied. Thereafter, she sold the property to Longplot, who is the current plaintiff in this case. And Longplot is currently seeking possession of the property. We want the property vacant. We're not seeking any monetary damages. We're just seeking possession of the property.
Thank you. I'll hear from Eric Seidenblad.
Hi, I would like to acknowledge, thank you very much. I would like to acknowledge that the RSO provisions on this house have never been acknowledged in the formal filing. When the box on the filing for a unlawful states, is this an RSO or rent protected property, one would think that you should actually check the box. Yes, this is a multi-unit property with a RD3 zoning. RD3 zoning is for multi-unit properties, which are, it's before 1978 built, which this house was built in 1910. Then they are automatically in the RSO HDCILA, Housing Commission Development Investment Department, coordination for rent stabilization. This house has not got a rent stabilization ordinance, renter's certification receipt, we call it certificate for legal rental. They have then subsequently rented it to people, the bottom flat, and have also ignored the fact that it has a 5 and 10 year Ellis eviction moratorium on anything other than a owner living in the property. And they have never acknowledged who the first right of first refusal to Ruben Pina or to Elishba, who have been here for an extremely long time. And they've given it to two of their friends who they supposedly get rent from, but it is clear that there's rent skimming, because if that was the case, they wouldn't be entering into a what do you call that, a default, not default, a mortgage foreclosure from being default on their mortgage as of yesterday.
Thank you. I'll hear from Ms. Elishba Seidenblad.
hi, thank you, Jan. I have something I wrote earlier to read out loud, and I will be presenting videos to show evidence my statements today. So this is a residential forcible retainer action filed on April 1st, 2020 for the premises located at 1410 Ewing Street. Plaintiff filed this action alleging a forcible detainer by defendants. This forcible detainer action arises from false claims wherein plaintiffs concocted a series of several and separate events that they themselves instigated, contorted the facts to use a theater of elements to meet the causes of action, and ultimately deprive defendants of their right to their property. And in the process, plaintiff has resorted to constructive eviction tactics, filing false papers with the court, inflicting emotional duress, attempting break-in, forcibly entering and detaining the lower property, 1968 Avon, performing illegal construction defects, acquiring title and permits by theft, by false pretenses, willful manipulating information, and ultimately wasting the court's resources. the following list of things are the construction eviction, attempted break-in, impersonation of a landlord, assault on Eric Steinglitz, false claims, false police reports, a police call log retrieved by CPR, California Public Records Act, harassment, stalking, forcible detainer, forcible entry on the 1968 unit, rent skimming with the fake renters they put in there, construction defects and damage to property and nuisance, and these damages have resulted in emotional and psychological duress, increased anxiety, causing stress and ulcers, loss of work, contract with television, was a television series we had, opportunity to, loss of time shared with families and loss of property, the lower unit, interrupted education and interrupted nonprofit mission goals with the Harlow Hamilton Health Department Conservancy. The cost, we've spent over three grand in researching and to prepare for this case and presenting as evidence, and personal injury to spine and ankle and unknown long-term effects from the 14-foot drop, which you'll see in the first video, and exacerbated both of our disabilities because I have narcolepsy and he's clinically bipolar 2 disorder diagnosed. And so we held actual possession at the time of the forcible entry complaint of, and an entitlement to possession pursuant to the doctrine of adverse possession, section 325, and evidenced by the notice of intent to preserve interest, affidavit of adverse possession, and affidavit of the assessment role as per 693 that is in the court record. And the improvements developed on the land as well as meeting the elements of adverse possession, which are open, exclusive, adverse, constructive, notice, and notorious. And so for they're guilty of forcible detainer pursuant to section 1160 of the California Civil Code Procedure because they unlawfully entered by force and by menace and threats of violence using a crew of 13 immigrant labor workers like a gang to intimidate defendants from entering the property, using tractors and heavy machinery in a threatening manner, and throwing rocks at defendants when watered the yard. And they refused to surrender when defendants posted the third no trespassing letters quoting LNC 41.24 and Penal Code 602L authorizing the police to arrest intruders, but no avail. And then forcible entry when they use tractors in a threatening manner to excavate the front yard, remove a Mexican elderberry tree, which is a protected tree, and forms a parking space upon the defendant's land, and parks there every day, using COVID-19 as a bile agent to terror, and by colluding to cough in our face in order to gain entry. And they've impersonation of a landlord, and they post a notice to inspect premises as landlord without identifying who they are. They are not our landlord at any time, and they posted it on the 20th day when they didn't technically have ownership until the 26th even, if, but their title is void because these claims are supported by, because the title is void because they acquired it through false success by false pretenses. And then these claims are supported by the fraud they commit in relation to this house. We are prepared to show a crew of 3 to 25 people who use real property in Los Angeles to launder money, create money, evade taxes, and commit multiple types of fraud in depriving the community at large. And they are, and each allegation, we are prepared to show a public record, and then or video illustrating the true reality. And numerous security cameras were installed due to the onslaught, and this case is an orchestrated event to defraud us of a purpose. And I think that, yeah.
Thank you very much. Plaintiff, call your first witness.
Thank you, Your Honor. I'd like to call Cheney Shapiro. Where would you like her to testify from, Your Honor? Thank you.
Witness stand.
Follow the stand there.
Please raise your right hand. Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. And please state and spell your name for the record.
Cheney Shapiro, Cheney Shapiro.
Can you spell your last name again, please?
Shapiro.
Is this microphone hooked up to the PA system or to the recording system?
That's hooked up to the
Yeah, we
recording system.
I cannot hear
There's
her.
two mics there. Tap on the one close, the bottom one. Yeah, tap on.
If you sit close to that microphone now?
Hello?
Thank you. You may examine the witness.
Thank you, Your Honor. Ms. Shapiro, are you the former owner of the property located at 1410 Ewing Street, Los Angeles?
I am.
Did you purchase that property on March the 3rd, 2020?
Yeah.
Who did you purchase it from?
The bank, I don't remember which bank, but
You paid money to them and you received a deed.
correct.
When you acquired the property, did you visit the property thereafter?
Yes.
And what did you see when you visited the property?
The house that is occupied by Elishba and Eric was boarded up.
What do you mean boarded up?
I mean, you
I
couldn't
can't
get
hear her.
I heard, Mr. Seidenblatt, I heard you speaking on your end. That makes it more difficult for you to hear, so I'd ask that you and the co-defendant not speak so that you can hear what's going on here. Please speak up, ma'am.
Okay.
Next question.
So what did you see when you got to the property?
It was very difficult to enter the property at all. The front gate was completely closed, locked. So
What's going
Acquired the property, did you visit the property thereafter?
yes,
And what did you see when you visited the property?
the house that is occupied by Elishba and Eric was boarded up.
What do you mean boarded up?
I mean, you
I
couldn't
can't
get
hear her.
I heard, Mr. Seidenblatt, I heard you speaking on your end. That makes it more difficult for you to hear, so I'd ask that you and the co-defendant not speak so that you can hear what's going on here. Please speak up, ma'am.
Okay.
Next question.
So what did you see when you got to the property?
It was very difficult to enter the property at all. The front gate was completely closed, padlocked, so we couldn't even get in. It had to go around from the side gate.
Speak up again.
Had to
Talk
go
louder.
around from the side gate to
Excuse me,
even.
stop. Can we turn up the volume on this? Do we have the ability to turn it up?
No,
No?
on her, not that I'm aware of. This is on this.
Mr. Winsky, can I ask for your help in manipulating the microphone stand so we can make it so that the witness is comfortable?
Okay.
She can sit back, but we can scoot her chair up closer to the microphone. We can scoot her chair up closer to the microphone,
Okay.
and we'll tilt it up so she doesn't have to bend her head down. And we can take a natural seated position there. Is that
That better?
comfortable, ma'am?
It's okay.
Ask your next question. Thank you.
So continuing, what else did you see when you got there?
The house, you couldn't get into the house. I could only see through the windows.
And what did you see when you looked through the windows?
It was a completely dilapidated house that didn't appear to be occupied at all. Falling apart, needs a lot of work, lots of renovations.
Was there plaster on the walls inside to the best of your knowledge?
I don't think so. You could barely see inside.
So
That's not occupiable. It's not livable, the house. The condition of the house, at least when I purchased it, was not livable. And there did not appear to be anyone living there.
did you knock on the
Your
door?
Honor, could she answer the question?
If she did, if that's an objection, it's overruled. Next question.
Did you knock on a door or a window?
Yes.
Did you get a response?
No.
Roughly, that was sometime after March the 3rd. Do you have some idea when that might have been?
Well, it was all only within about a month that we were trying, and then we started just working on the front house first, which was the plan, to renovate up there.
The question was, what day was that, ma'am?
Which,
When you went to the property, what day was that?
I don't know exactly what the date
Next
was.
question.
Okay. I didn't hear, I thought that was an objection by the
It's not.
Okay, thank you, Honor. Did you turn around and, I'm sorry. Did you at some point believe there were people living at the property?
I was told that there might be people living there at one point, yes.
Did you employ the offices of Simonian and Associates to bring in a forcible detainer because you believe there were people at the property?
Yes.
And was that was in April of 2020?
Yep.
Thereafter, did you decide to sell the property to Longplot and Associates,
I did.
a Longplot and Company?
Yeah.
And did you do that on May the 15th of 2020?
Yes.
I have no further questions of this witness, Your Honor.
Mr. Seidenglantz, you may examine the witness.
Okay, yeah, thank you. So when you went and looked through the window and the door, what did you see?
Well, besides what I already answered, because I answered that question.
Ma'am,
Yeah.
did you hear the question?
Yeah.
Don't argue with the person asking, just answer the
Okay.
question. What's the answer to the question?
I saw a dilapidated house that looked unoccupiable.
Thank you. Next question.
What was the address of the place that you looked at?
1410 Ewing Street.
Objection, that's impossible. The house was...
Objection is your objection is overruled. Merely state your objection, the grounds, and then wait for the ruling. Next question.
Okay, got it. When you observed the property and you said that you saw plaster on the inside of the property, can you explain a little bit more about the plaster you saw?
I didn't say that I saw plaster in the property.
Oh, I'm sorry, I thought your lawyer did it for you.
Nope.
You have any further questions, Mr. Seidenglantz?
Yes, I do.
Go ahead. Ask your next question.
So you received the property in March. And whom did you receive the property from in March?
We bought it from the bank.
What bank?
I forget the name of the bank.
Objection, relevancy.
What was that?
She forgets the name of the bank. Objection, relevance, overruled. Next question.
Cheney Shapiro writes in her statement that she buys it from a bank where she signed under...
Mr. Seidenglantz, ask your next question.
Okay. The purchase of the property was supposedly on March the 6th, but it is not reconveyed until March 26th. Is there any reason that you can explain why you're not actually conveyed the property until March 26th?
I don't understand the question. It's unintelligible. It's argumentative. I have sustained my own objection. Next question.
I'll reframe it.
Please.
The title insurance for the house was acquired on what day?
Objection, relevancy.
Sustained. Next question.
Wait. Well, if...
Next question.
Okay.
Yeah.
Whom else might you have shown the property to before March the 19th?
Objection, relevancy.
Sustained.
Joyce Essex Harvey is the person who sells the property, supposedly, as the listing agent. I'd like to know who is the selling agent on the property.
Objection, relevancy.
Do you know who the selling agent is? With what? The purchase from the bank or the sale to Lumplot?
Both. They're quite simple.
Objection, relevancy, Your Honor.
Sustained. Next question. Next question.
It's an extremely relevant question.
Mr. Seidenglantz, ask your next question. I've ruled on the objection.
All right. Who is your father and what does he do for a living?
Objection, relevancy.
Overruled.
Does that mean I answered that?
Yes, you may answer.
My father is a realtor. Ken Shapiro.
Do you or do you not work for Silverwood Properties?
I do
Objection,
not.
relevancy.
Overruled. Did you hear the answer, Mr. Seidenglantz?
Yeah, well, no, I didn't.
What's the answer, ma'am?
I do not.
Next question.
in your statement in your filing, you state that you're an employee of Silverwood Properties, and that you write in our notice to 5-day notice for us that you are the you put the phone number for Silverwood Properties that is the landlord of. You do not sign your name. Is there any good reason why you would not put your name and why you use the phone number of Silverwood Properties if that is not your employer or relationship is not tentative?
Objection compound.
Sustained.
What is your email?
Objection relevancy.
Sustained. Mr. Seidenglantz, Ms. Shapiro has testified to certain limited facts. On cross-examination, you're to examine her on facts that arise from what she testified to on direct. Do you have any other questions regarding this witness?
Yes, I do.
Please ask your next question, sir.
Sorry, I have to check my notes here. On March the 19th, do you or do you not address the property with Joshua Markinson on the outside of the fence?
Objection relevancy.
Overruled.
I don't remember.
Are you currently, or have you been recently involved in a case with other people in the Elysian Park neighborhood for similar problems of deficit and fraud?
Objection compound and relevancy.
Sustained. Do you have any other questions regarding her direct testimony, Mr. Seidenglantz?
Yes, my wife does.
All right, then we'll hear from Ms. Seidenglantz. Ms. Seidenglantz, your questions of the witness.
Yes.
She just needs 5 seconds to find her place in the book.
What day did you serve the notice to quit? 5-day notice to quit? Or what day did you serve the 5-day notice to quit?
I don't recall.
Mr. Winsky, will there be testimony regarding the service of the 5-day notice in this trial?
I neglected to do that, but since it's now been reopened, I'm going to recall that question and bring it to the court's attention in just a moment.
From a witness who doesn't recall?
It was not served by her, Your Honor.
Very good. Next question?
Oh, say that again?
Ask your next question, please.
What day did you file the notice of intent to inspect the premises?
Objection relevancy.
Or not
Sustained.
file, sorry, sir.
New question, sir.
Okay.
Is there an objection to the new question?
I didn't give the new question. I'm
Not fair, but what day did she serve that document?
Objection relevancy, Your Honor.
Sustained. Ms. Seidenglantz, do you have any other questions regarding the direct testimony?
Yes,
Yes.
oh, yes. When you say that, when you purchased the property, what was the APN to the property?
Objection
APN
relevancy.
stands for assessor's parcel number.
Overruled. Do you know the APN, ma'am?
Not off the top of my head.
The permit for your
Mr. Seidenglantz, you've asked your question. This is Ms. Seidenglantz's opportunity. Ms. Seidenglantz, do you have any other questions?
Yes.
Go ahead.
Did you, on what day was hold on, on what day was, when you visited the property to, look at it, did you notice, other tenants, or the residents living here? Yes, that's the question.
Objection to the form of the question. I don't understand the question.
Overruled.
No, I did not.
What was that?
She said no, she did not.
Okay. What, on the, you mentioned that, these, like a barricade? Can you describe the barricade?
I don't remember saying there was a barricade.
What?
I don't recall saying there was a barricade.
It's in your file.
Mr. Seidenglantz, I must insist on you stop asking questions and making comments during the examination by other parties. Please, sir. Next question, Ms. Seidenglantz.
Yes. When was the photo taken that was Exhibit 5 in your original ex parte application for a writ of possession, the declaration of Cheney Shapiro?
Objection to the form of the question, Your Honor.
When was a photo taken?
When was a photo taken in relationship to something in a document that?
I thought, well, when was the photo taken? That photo was Exhibit 5 or something.
Something, yeah, but that's the lack of foundation then. I don't know that there's anything that we can do. Not knowing what document.
Sustained. It's difficult to know what photo you're talking about without showing it to the witness, ma'am.
It's the only photo that was filed with the court regarding by the plaintiff.
Ask your next question and identify where she can find the photo, and if necessary, you can show the witness the photo. Ask your next question.
Okay. On what day did you take a photo of Eric Seidenglantz that you provided to the court as to file your ex parte application to specially enter default judgment and issue writ due to necessity to protect public health and safety declaration of telephonic notice? Yes, notice of this.
Objection, compound.
Overruled. When did you take the photo, ma'am?
I don't know what photo they're talking about.
All right. Next question.
Did you know the house was in REIT?
Objection,
Rent reduction.
Sustained. The relevancy objection is sustained. Ms. Seidenglantz, do you have any other questions of this witness from what she testified to earlier?
Yes. Did you know about the house being active?
Objection, relevancy.
Did you know, ma'am?
I'm sorry, I didn't hear it.
Could you repeat your question, please?
Did you know the house was Ellis active according to the Chicago report?
Objection, relevancy.
What's the relevance of that question, Ms. Seidenglantz?
The Ellis Act would not allow the...
No, why is that important? Why is that important with this witness based on what she testified to?
I apologize, Your Honor, I'm new to this. They would have had to know this to purchase the property, and it wouldn't have been sellable.
Objection, objection overruled. I'm sorry, objection sustained. Ask your next question.
I think we'll take over, sir. All right.
Thank you. Thank you. You may be seated.
Your Honor,
Thank you for your testimony.
I would like to redirect the question based on
All right.
one of the questions, Your Honor.
Redirect, which will allow recross. Go right ahead.
Okay, thank you, Your Honor. So, after you purchased the property, before you sold it to Lung Plot, did you contact the Timonian law firm about a lawsuit?
Yes,
And did they prepare a 5-day notice to quit based on that information?
yes.
May I approach, Your Honor?
Yes.
I want to show you a document called 5-day notice to quit.
Are we going to mark the document?
It is Exhibit 2 to the plaintiff. We'll make it Exhibit. Yes, we have a notice of trial for today's date. That should be 1. I'm not sure. But we'll make this 1 or 2 depending on the court wants to identify it.
Do we have a joint binder that we can refer to so that Seidenglantz can follow with us?
This is attached to the complaint, which is included in the document.
All right, go ahead.
As well. So is this a direct copy of the 5-day notice?
Yeah,
And you employ the law firm to do it, and they use the registered processor.
correct.
So the 5-day notice and proof of service collectively plaintiffs won for trial today.
Can it be marked as Exhibit 1, Your Honor?
Yes.
That's fine.
This is the, how many day notice?
5-day notice.
5-day notice.
Enforceable detainer case.
Thank you.
No further questions.
Thank you, Mr. Seidenglass. Recross on the issue of this 5-day notice.
I would like to call into to reference a video that is in our evidence filing on a YouTube playlist that is of the specific incident. Is that a procedure that I may work with to ask the question? The question is within the context of the video. It would be what date is the video and who is doing the work in the video, who is there, who is present.
What does that have to do with the 5-day notice, Mr. Seidenglass? Do you have any questions about the 5-day notice?
Yes, I do. More importantly, the 5-day notice that we...
No, I'm not arguing with you. It's time for you to ask any question about the 5-day notice of this witness.
All right. The 5-day notice that was supposedly served by Simone and Ross was not signed as far as I was aware, and I would like to know whether or not you remember signing it or not.
Did you sign the 5-day notice?
I do not believe so. No.
All right.
What was that?
She said no, she didn't sign the 5-day notice.
So there was no name of anybody on there that was the landlord other than the word landlord. Is that correct?
I'd have to look at the document. I don't remember the wording on the document exactly.
What did she say? I'm sorry.
Can you repeat that? It's very hard to hear, sorry.
Can you repeat that, ma'am?
I don't totally understand the question.
Re-ask your question.
Whose name was signed or not signed on that document for the landlord? Was there a name signed onto that document?
I didn't serve the
Mr.
document.
Wadinsky, do you have a copy of the 5-day notice to quit, Exhibit 1?
It's in front of the witness right now.
Ma'am, do you have the document in front of you?
I do, yeah.
Is your name or signature on that document?
My name is on the document. but
Ask
not
your
signature.
question one more time, sir. She has the document in front of her now.
Yes, I will. Did you not just say a minute ago that your name was not signed on that document?
It is not signed. It is written. It's printed on the document.
Okay, and to whom did you address this to?
Patrick and Debbie Murray.
And whom are Patrick and Debbie Murray to you?
I don't recall why there was confusion at the beginning of this case as to who was on the property and occupying it. And somehow that
Did you ever live on Lincoln Street in Clearwater, Florida?
Objection, relevancy.
What's the relevancy of that, Mr. Seidenglass?
Debbie and Patrick Murray are members of their congregation and are a cleared level in the Church of Scientology and are real estate brokers that work directly with Cheney Shapiro and her father, Ken Shapiro, of Silverwood Properties, and are directly terrifying because they are involved in kidnapping of other people in previous cases over property.
Thank you. The objection is sustained. Next question.
Do you admit that?
Ms. Seidenglass, it's not your turn yet, ma'am. Mr. Seidenglass, are you done with your question?
No, not quite.
Let's ask questions about the 5-day notice, sir, please.
The 5-day notice you're saying was delivered on what day? Just clarifying.
it looks like
Is
March.
this witness testifying to the service of the 5-day notice?
Only to the extent that there's proof of service by registered process server attached to it, Your Honor.
Do you know what day it was served, ma'am?
You turn over the next page and may help you refresh your recollection.
I mean, it's
The
written.
next page.
What day was the document served?
It's hard to read it on this copy here, but it looks like 3/28? 3/28 or 3/21? No, I'm sorry, 3/21. March 21st.
All right. Next question.
Do you recall shooting a photograph of yourself serving the document on our gate on the 20th?
I do not.
Do you recall yourself doing that on the 21st?
Nope.
Do you recall yourself doing it on the 3rd of April?
I do not recall that.
Would you be willing to testify under penalty of perjury that you did not serve these documents at any time?
That's argumentative. The court sustains its own objection. The witness is under oath. Ask your next question.
Who else do you share the responsibilities of the property transfer with?
Objection, relevancy, Your Honor, also.
I'm sorry, I didn't mean to, I got convoluted there, sorry. Do you know who Richard Justin Williams is, and did you serve with him these documents?
Objection, relevancy, Your Honor.
Overruled. Do you know who that is, ma'am? And you served them with the document.
Well, did I serve him with the I don't understand. I do know who he is, yes.
Who is he?
He is a contractor that we use and also my significant other.
All right. Next question.
When you say that we use, who do you mean we when you say we use?
Objection, relevancy.
Overruled.
Oh, I'm sorry. Answer that.
Yes.
We, me, and whoever I might partner with on whatever project.
And whom are you partnered with on this project? When you say
Objection,
we?
relevancy, Your Honor.
What's the relevancy, Mr. Seidenglass?
I mean, it'd be nice to know who her partner is in this business that we supposedly are being sued for.
Nice to know is not grounds for discovery. Objection sustained. Next question.
Well, Cheney Shapiro writes in her declaration that...
Next question, Mr. Seidenglass. We're not arguing with the court over objections.
I'm not. I was asking if...
Okay, please. Please.
In the declaration, Cheney Shapiro writes that she transfers the property to Long Flat Co. On what date did this transfer actually have happened? When did it go through?
Objection, relevancy.
Overruled. What day did you sell the property, ma'am?
May or June, I can't recall exactly, approximately 3 months after I purchased it.
And
Do you have any other questions about the 5-day notice, Mr. Seidenglass?
not the 5-day notice in particular.
All right, well, that's all we're talking about right now, because that's the only question that was posed on redirect. Ms. Seidenglass, your chance to ask questions about the 5-day notice.
I think I'm okay.
Thank you. You're excused, ma'am. Thanks for your testimony.
Thank you.
Please call your next witness.
Thank you. Sir?
Are you calling any additional witnesses?
Yes, ma'am. Come forward, sir.
Your name?
State your name.
Josh Moxon.
Please approach the witness stand and be prepared to be sworn.
Please raise your right hand. You solemnly state the testimony you may give in the cause now before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. And please state and spell your name for the record.
Joshua Marcuson, Joshuamarc.
In the declaration, Cheney Shapiro writes that she transfers the property to Long Flat Co. On what date did this transfer actually have happened? When did it go through?
Objection, relevancy.
Overruled. What day did you sell the property, ma'am?
May or June, I can't recall exactly, approximately 3 months after I purchased it.
And
Do you have any other questions about the 5-day notice, Mr. Seidenglass?
not the 5-day notice in particular.
All right, well, that's all we're talking about right now, because that's the only question that was posed on redirect. Ms. Seidenglass, your chance to ask questions about the 5-day notice.
I think I'm okay.
Thank you. You're excused, ma'am. Thanks for your testimony.
Thank you.
Please call your next witness.
Thank you. Sir?
Are you calling any additional witnesses?
Yes, ma'am. Come forward,
Your
sir.
name?
State your name.
Josh Moxon.
Please approach the witness stand and be prepared to be sworn.
Please raise your right hand. You solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. And please state and spell your name for the record.
Joshua Marcuson, Joshuamarcuson.
You may examine the witness.
Mr. Markison, are you related in some fashion to Longplot?
Yes.
What's your relationship to Longplot?
It's my company.
And what kind of company is it?
House renovation.
And did you purchase the subject premises from the Shapiros?
I did.
And you paid money for that?
Yes.
And you paid it knowing that there was a notice had been filed and complaints had been filed in this lawsuit?
Yes.
When you purchased the property, you learned that there were people allegedly living in the property as well.
I knew there was some sort of situation with some squatters.
And you've been to the property many times and tried to get their attention.
I've been a few times. Yes.
Have you knocked on the door?
Yes.
Has anybody answered?
No.
Did you put cameras at the property?
Yes.
What happened to the cameras?
They were taken from the lower house that we were working on by Mr. Seidenglass. We had it on footage of him taking them off.
You made a motion, or a motion was made to rename this case in your name rather than Shapiro's name, is that correct?
Correct.
And to the best of your knowledge, the defendants are still in possession of the property. They haven't relinquished it to you in any way.
No, they haven't.
Nothing further?
Mr. Seidenglass, you may inquire of the witness. Mr. Seidenglass? Ms. Seidenglass? Mr. Winsky, do you have a phone number for the defense?
I do not.
Winsky, can you get a phone number for the defense?
I can try and see if any of the documents that they provided us have any phone numbers on it. We've been communicating by email predominantly. I can try and email them.
Anything you could do, I would appreciate.
Sure.
See what the status is of the Seidenglasses.
I will email them right now, Your Honor.
Thank you, sir.
Hi,
Okay.
Oh, Ms. Seidenglass, you're there? Very good. Ms. Seidenglass are back. Mr. Seidenglass, you may examine the witness.
Okay. Yeah. Okay, one moment. We just have to resituate. 2 seconds.
What just happened? Because we lost you. We didn't hear anything that happened for the last, since you called Joshua Markison, we had technical problems with the internet cutting out and the signal was cutting out for us.
Mr. Markison has testified that his company purchased the home, that he purchased it from the Shapiros. He was aware there were people living there, squatters. He visited the property a few times. He knocked. There was no answer. He installed cameras at the property, and the cameras were taken from the lower house by Mr. Seidenglass. He has them on camera, taking the camera, and the defendants remain in possession. You may examine the witness, Mr. Seidenglass.
On what day did you visit the property?
I don't recall the exact date.
That, I don't know.
He said, I don't recall the exact date. Sir, please keep your voice up. Perhaps if you raise the microphone at the same level as your mouth. Perfect, thank you. Next question.
Do you remember discussing the placement of a parking spot in a dirt patch on the top of 1410, right where the abandoned property is next door?
Objection, relevancy?
What's the relevancy, Mr. Seidenglass?
Well, I clearly have video of them not getting in the property and only standing on my fence line and talking about cutting down my black walnut, and it's clear as day.
Objection sustained. Next question based on his direct testimony.
Are you a arborist?
Objection, relevancy?
Overruled.
Yes, I trained as an arborist in the UK.
Where was that? You went to arborist school?
Capel Manor College in Enfield, North London.
And you have a degree.
It's a national diploma.
What is that?
A
Can I make another
recognized
objection, Your Honor?
certification.
What's the objection?
It's relevancy.
I really can't hear you, that's all.
The objection is sustained on relevancy grounds. Do you have any questions regarding Mr. Markison's testimony?
Yes. I didn't hear the testimony, so how can I technically make an objection?
I summarized his testimony when you dropped out. Based on that summary, do you have any other questions regarding his testimony?
I didn't hear the summary.
I just told you what the summary was. I told you what he testified to on direct.
I'm doing my best to follow, but I did not hear it. I'm sorry.
That's okay. I don't mind repeating it. If you don't hear something, please let me know. Mr. Markinson testified that Lumquat is his company. They're involved in house renovations. He purchased the property from Shapiro. He knew that there were people living there. He called them squatters. He visited the property a few times. He would knock on the door, no answer. He installed cameras at the property. The camera from the lower house was taken down. He said it was taken down by Mr. Eric Seidenglantz because he saw him on the camera taking it down. And he testified that the defendants remain in possession of the property. That's the state of his testimony.
I have a question. The picture you have of Mr. Seidenglantz and myself, supposedly, performing this decammering, what resolution camera is the device that you installed?
I don't recall the exact resolution. It was a camera I purchased and just installed.
Can't hear it.
Sir, you've got to keep your voice up, and I want you to pretend like we're outside now.
Got it.
What's the answer to the question?
I don't recall the
Thank you.
exact
Next
resolution.
question.
The picture you provided for the case filing shows two blurry individuals that have no recollection ability, no recallability at all. Is there any way that you can say that you for sure know whom that is removing the cameras?
Objection, relevancy, lack of foundation.
Overruled. You know who was in the photograph, sir?
Yes, it was you and your partner.
Thank you. Next question.
And by what means do you know that if the resolution is something that you have to call into question?
Because it was good enough resolution to see.
So how come it isn't good enough in the provided documents that you supplied to the court? There's no way anyone could see that.
Objection, relevancy, Your Honor.
Objection is sustained. It's argumentative. Please don't argue with the witness, Mr. Seidenglantz. Mr. Seidenglantz, you're going to have an opportunity to present witnesses. You don't need to prove your entire case through every witness. You may only ask the witnesses questions that are related to their previous testimony on direct. Do you have any other questions of this witness on his testimony?
I apologize for not knowing the formal proceedings.
No, you don't have to apologize, but don't argue with the witness. If you don't like the answer, just move on, and you'll have a chance to present your evidence. But don't argue with the witness.
It's in my nature. It's why I went to college was for discourse.
I'm sorry, I don't understand that, but in this court, please don't argue with the witnesses. Next question, Mr. Seidenglantz.
On what is the address of your proof of your agent for service of process on Long Flat Co?
Objection, relevancy.
Sustained.
Do you know that the house was is an RSO and has certain protections that are provided to it?
Objection, relevancy.
Overruled.
I would need to be reminded of what an RSO is.
Rent stabilization ordinance.
And the question is?
What's your question? He has asked, what is the question about the RSO?
Do you know this house is a RSO house? It is 100% an RSO.
Objection, relevancy, since this is a forcible detainer, Your Honor.
It's a fact. It's prima facie.
The objection is overruled. The objection on assumes facts, not as evidence, is sustained. Next question.
Did you know that the title report clearly states that there is currently an Ellis Act covenant for overshadowing the house's title?
Same objection, Your Honor.
Sustained. Next question.
Did you know that your title insurer literally gave you 1 day of title insurance?
Same objection, Your Honor.
Sustained. Mr. Seidenglantz, do you have any questions based on Mr. Markinson's testimony previously?
Yes, I do. What color was the door?
Objection, relevancy.
Overruled. He said he testified that he knocked on it. He's entitled to know the color of the door.
I don't recall because of the state of the property was so dilapidated. It's not clear.
And the windows, when you saw them, they were visible to be seen through?
Partially, due to the
What was
condition.
obscuring them?
They weren't clean. There's remnants of curtains and stuff of that sort in the way.
If this house was in such deferred maintenance, wouldn't it be plausible or realistic to say that you actually must get a property report called an RPR, and that property RPR would require you to facilitate certain Los Angeles ordinances for sale of real property that would incur you to get a tenant habitability plan if it's an RSO, if there were people living inside of it?
Objection to the form of the question, also relevancy.
Sustained.
If I lived in this house before 2019, do you know what that means, Joshua?
Objection, form of the question, Your Honor.
Sustained.
Joshua, have I not contacted you specifically about discussing the matter so that I could give you personal evidence that would help you?
Mr. Seidenglantz, please refer to the witness by their last name, not their first name, and re-ask your question.
Okay. Sorry, Joshua Markinson. I'm sorry. I apologize.
Mr. Seidenglantz, please don't do that. I just told you not to call him by his first name, and you did it again. I don't know why you did that. I'm going to overlook it. Please don't do that again. The witness is Mr. Markinson. Do you have any questions for Mr. Markinson?
I apologize. It was a mnemonic device. It just got stuck in my head because you said it.
You don't have to apologize. I'm asking you again. Do you have any questions for Mr. Markinson?
Yes.
Please ask your next question, sir.
What kind of car do you drive?
Objection, relevancy.
Sustained.
All right. I guess I'll let my wife go.
Thank you. Ms. Seidenglantz, questions for Mr. Markinson?
Yes, thank you. Do you perform home renovations with Cheney Shapiro?
Vague as to property, where the question is asking, Your Honor?
Does he perform home renovations for Ms. Shapiro?
I'm sorry, I thought he said, did he perform at the property?
Home renovations for Ms. Shapiro.
Thank
You do work for Ms. Shapiro?
Yes, we have done projects together.
Okay. And in the past, have you, and in this instance, do you pull permits for Shapiro? Mr. Shapiro?
Objection, relevancy.
What's the relevancy, Ms. Seidenglantz?
There's permits pulled on 1968 Avon that are pulled on a false APN number that was deleted by the assessor in order by resourceful construction and Cheney's significant other and Mr. Markinson is noted as the applicant.
All right, the objection is sustained. Next question, ma'am.
Yes. Where did you install the cameras?
On, I think, 3 corners of the building and 1 on the roof.
Okay. Okay. What? I would call it a deputy, but where were they pointed? What direction were they pointed in?
The ones on the front of the property were pointing at kind of cross angles across the front of the property. The one at the back was pointing across the back of the property, and the one on the roof was pointing to the back wall of the property.
What was the last one?
The one on the roof pointing to the back wall of the property.
The back. Which wall?
Your Honor, I'm going to object at this point. Mrs. Seidenglass is also asking questions now.
Mr. Seidenglass, I ask that you remain quiet during the time that Ms. Seidenglass is asking her question. Ms. Seidenglass, ask your next question.
Okay. What is the wall that you were talking about?
Just the back of the property.
The back of the property. And then what? One moment. did you say you installed the cameras?
Yes.
Yes. Can you repeat who installed the cameras?
Myself and some of the people that are employed by us to do work.
And how many are employed by, sorry, say that again?
Some of the people employed to do the work on the renovations and myself and put the cameras up. I did the technical, the monitor, and they put the cameras on the building.
Okay, and who are they? Who are the people that are employed?
Exemption
Employees.
relevancy.
Sustained?
Okay. Did you know that there, do you remember pulling a abandoned tree, protected tree from the property?
No, we haven't done
Relevancy.
anything.
Considering you're an arborist?
Mr. Markinson, I've asked that you delay answering to give me a chance to rule on any objection.
Understood.
The objection is sustained.
Okay. And did you know, and upon purchasing the property, what is the APN to the property?
Objection relevancy.
Sustained.
Okay, let's see. What is the APN number ending in 3000?
I sustain that objection, ma'am. Do you have any other questions to ask the witness about his testimony?
Yes, I do. I'm just trying to recall it.
Please ask your next question.
Couple more, hold on. What location? Sorry, I'm just recalling his testimony. It was, oh yeah, what is the first day that you came on the property? That you knocked on the door?
I don't recall the exact date.
Sorry, say that again?
I
You
don't
say you
recall.
didn't recall the exact date.
Okay. And, okay, I guess. And can you describe what the house looked like? Both houses looked like when you came on the property? Not just one?
Yes, they were in very poor condition.
What was the color of the plaster?
In which part are you referring to?
Well, okay. Well, you both mentioned that the house is in poor condition and both have plaster in your declarations, and so I wanted to know what color was the plaster?
Do you remember what color the plaster was, sir?
In the lower house, there was old plaster that wasn't a particular color because of the age and condition of deterioration. So it's very hard to specify what color.
Okay. There were three colors, actually. So,
Are you testifying this side and glance, or do you have any other questions?
yeah, I do. I'm just getting back. Just trying to find my papers.
All right, if you don't have any other questions, we'll prepare to take our noon recess. Have you completed your questioning, Ms. Seiglass?
Okay, that's it.
All right, may this witness be excused?
Just one final question, Your Honor.
Please, go ahead.
Thank you. You've never been inside the side and glass house, is that correct?
No, I haven't.
Thank you. Nothing further.
Mr. Seiglass, do you have any questions based on that question?
Oh.
Mr. Seiglass,
Were you able
Mr. Seiglass, do you have any questions of this witness based on that question?
Yes,
Go ahead, sir.
yes. You said you could see through the window, but barely.
No, that's not the question. The question is,
Oh, no, the question has,
go ahead.
that's a comma. So upon seeing through it barely, what was the view that you could see? You had to see something.
Objection asked and answered.
Overruled. Cross-examination. That's what happens when you have redirect, you get recross.
I know that. I understand the question, Mr.
You
Marks.
can answer the question, sir.
Yes, I saw A building that was in poor condition, didn't look habitable, deterioration of the wall surfaces and the floors, mess, remnants of trash. Basically, yeah, that's what I saw.
And we're talking about 1410 Ewing?
Yes.
Do you at all recall seeing the opposite wall through the window in the front room?
No, I don't recall.
Or do you recall seeing the living room through the other front window?
Not exactly, no.
Do you recall what color, I already asked you what color door, do you recall what color the security screen door is?
The court will interject its own objection under Evidence Code Section 352. Do you have any other questions, Mr. Seidenglantz, regarding the issue posed
Yes.
by the redirect question? Go ahead and ask them.
I do. Are you, do you know the APN number for the property that you pulled the permit on?
Objection
That
relevant.
objection is sustained. Ms. Seidenglantz, do you have any questions of the witness?
Do you remember what the color of the curtains were?
The court has sustained an objection under 352 regarding the color of the curtains and the color of the plaster. Based on the testimony, the court believes it's an undue consumption of time. Do you have any other questions regarding this witness, Ms. Seidenglantz?
Okay, I didn't say. What second? So, what's what? Do you have no knowledge, sorry, that's not it. What, was there a fence to the property?
There was a chain link fence along the curb side of the street.
Okay. On the curb side of the street, you said?
Yes.
Okay. And, when did you form the company Long Flat Coat?
Thank you for your questions. The court sustains objection under 352. You may ask the witness questions regarding the last inquiry, not anything more than that.
I understand, I'm sorry.
Do you have any questions regarding that?
What was the last inquiry?
The condition of the property inside. Did he look inside?
Oh, yeah. Oh, okay. I see. Oh, yeah. What floor did you see when you saw the inside of the property?
352 again, Jim.
Overruled.
The top
Okay.
floor. Or upper level.
Sorry, say that again?
He said he saw the upper level.
Upper level. And did you notice tenants living here
No, I didn't.
at the time? You didn't notice.
No.
Did you notice the huge no trespassing sign?
I don't recall seeing that.
Do you have any other questions regarding this witness's testimony as to looking inside the house, ma'am?
Okay, and then, okay. And then, did you see the wooden gate?
Objection.
Sorry, inside the house. I recall, that's my question.
All right. Do you have any other questions, ma'am? Are we done?
Do you remember flying a drone around the property to look inside the property with the drone?
I've never done anything like that, no.
Okay. That concludes the testimony of this witness. Thank you for your testimony. You're excused. We'll take our afternoon recess. We'll take out the session at 1. We're back on the record in the Cheney Shapiro versus Patrick Murray case, 20 STUD 2828. We're in trial. Mr. Wadinsky is present on behalf of the plaintiff. Mr. Eric Seidenglass and Elishba Seidenglass are on the phone. Can you hear me? Seidenglass?
I can hear you.
Very good.
I can hear you.
Is Ms. Seidenglass with you, sir?
She's incapacitated, but will be with us in one moment. I just have to wake her up. She's narcoleptic. Give me 2 minutes. 1 minute. Hello, wake up. She's awake. Okay.
Very good. All right, we're back on record for the trial. we've concluded witness Cheney Shapiro and Joshua Markinson. The case is with the plaintiff.
We still have one more witness, Your Honor, Panos Panyan.
All right,
Panyan?
please come forward to be sworn.
Oh, over here, this way.
Over here.
Face the clerk,
Raise your
raise your
hand.
right hand.
Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated. And please state and spell your name.
My name is Panoyan, P-A-N-O-S, P-A-N-O-Y-A-N.
P-A-N-O-S.
P-A-N-O-Y-A-N. That's my last name.
P-A-N-O-Y-A-N.
Yes, sir.
Thank you, sir. Panoyan?
Panoyan.
Panoyan.
Last name again?
P-A-N-O-Y-A-N.
That's his last name. I think it's his first name. Right?
Panos. P-A-N-O-S.
Thank you.
Thank you. You may examine the witness.
Thank you. Sir, you're a California registered process server?
Yes, sir.
What's your registration number?
It's 2014133019.
And you're registered in the County of Los Angeles?
Yes, sir.
How long have you been doing that job?
It's about 16 years.
Do you recall going to the property at 1410 Ewing Street in Los Angeles in March of 2020?
Yes, I do.
And what did you go there for?
I went there to serve a notice.
Sir, can you be sure to cover your nose with your mouth? Thank you.
You went to serve a notice?
Yes.
Do you recall what date you did that? Was it March the 21st?
The 21st.
What
It's
do
a
you-
Saturday, yes.
What do you recall about that date?
I went to the property and I knocked the bell, rang the bell, and nobody answered, so I posted the notice on the door.
Did you mail a copy thereafter?
Yes, I did.
I want you to look at the paper that's in front of you there. Does that reflect the document that you served? Copy of the document you served?
Yes.
And on the next page, there's a proof of service. Is that your proof of service for that service?
Should we identify for the record the documents?
I'm sorry, plaintiff's one.
Yes, I served this 5-day notice.
You served that 5-day notice?
Yes, I did.
And what time of day did you do that?
It was in the morning time.
And how do you remember it was in the morning time?
It was a Saturday morning because I cut my finger when I was posting the notice. I remember.
Thank you. I don't have any further questions, Your Honor.
Mr. Seidenglantz, you may examine the witness, sir.
Could I get a reprisal of the last couple sentences? I could not hear the witness.
He remembers serving the 5-day notice because that Saturday morning when he was serving it and posting it, he cut his finger.
I remember that.
Is there somebody playing, Mr. Seidenglantz, is somebody playing the guitar? I hear guitar strings.
No one's playing it. It's just been nearby and got plucked twice on accident. Sorry.
That's okay. When you pluck the guitar strings, I hear the chord, and it's more difficult to hear you speak. So if we could reposition the guitar so it doesn't get plucked while you're asking your questions, I'd appreciate it, please.
I would totally work with you on that. No problem.
Thank you. You may examine the witness, sir.
So when, okay, Mr. Tanya, how do I pronounce your last name again? So I don't butcher it, please.
Panoyan.
Anyone?
Panoyan.
Okay, thank you, Panoyan. Do you work for Jacqueline Grace Pelez as a process server for other cases?
I didn't understand your question. Do I work? Can you repeat it again?
Do you work for Jacqueline Grace Pelez's law firm, Simonian Law, directly as your main business of process serving?
No, I don't. I'm a processor. I work with a lot of different attorneys.
Has Jacqueline Grace Pelez been your lawyer for process serving conflicts of interest in the prior cases?
Objection asked and answered.
Asked and answered, inappropriate,
Sorry.
overruled on cross-examination.
Thank you.
All right, no problem. All right.
You may answer the question, sir.
When you pricked your finger on the gate, do you recall what you did right after?
What did I do right after the door has nails that are sticking out from the other side. So when I was posting a notice, I poked my finger. So I was trying to wipe it off. I mean,
I think you answered the question. Next question.
No problem. That's accurate. Do you recall that you were wearing a mask or not, due to the mask provisions, whether or not you were actually performing this act with a mask on?
I wasn't wearing a mask, no.
Do you recall that your testimony states that you served a person of different height and color than 5'7" and sandy blonde? You stated you served a person with 5'9" or something like that, and sandy blonde red.
Objection mistakes the evidence.
Sustained.
His statement. I'm sorry for the real ruffling and noises over here. What color do you recall the hair of the individual you delivered the service to?
Objection mistakes the evidence.
I posted it. I didn't see anybody this day. This is the
You wrote it down. I want you to recall what you wrote down.
Did you write down that you served somebody?
No.
Next question, please.
But that's not.
Let's not argue with the witness. Let's just ask your next question, please.
Oh, guys, sorry to interrupt. It's Daniel Resch. I'm a witness for the Fighting Land Party. Just acknowledge that I'm here on the phone line.
Thank you. Please mute yourself. Let's ask your next question, Mr. Seidenblatt.
How many times did you return in the same exact visit, Mr. Penyon?
How many times? I don't understand what he's saying. How many
Did you
times?
go back more than one time on March 21st?
No, one time.
All right.
He did not drive up, get out of your car, get back in your car, get out of your car, get back in your car, switch the papers again, and then leave going downhill, then turn around and go back uphill.
Objection to the form of the question. It's a question.
What this guy's talking about.
And did you do all those chaotic things I just described that were literally a circus of driving up and down the street, parking multiple times, getting in and out of the car, parking in different places, and switching the documents 3 times?
The court will sustain its own objection under 352. Let's ask your next question, Mr. Seidenblatt, please.
Did Mr. Penyon park his car in the middle and switch the documents?
No.
Did Mr. Penyon cut at our ring camera and fiddle with our mailbox?
No.
Did Mr. Penyon touch the mailbox in any way?
No.
Did Mr. Penyon realize that a ring camera actually records?
No.
Okay, well...
No, ask your next question. That's all. Okay. Ms. Seidenblatt, do you have any questions of the witness?
Yes, we do. What was the document you said, according to your declaration of service of the notice of termination document?
I didn't understand. I couldn't hear the question, Your Honor.
There's an objection, unintelligible. Please restate your question. Sustained.
Yeah, sorry. What was the document you said on March 21st?
What document did you serve on March 21st?
I served the 5-day notice.
And how did you serve this document?
How did I serve it?
Yes, what was your method of serving this document?
May I see that document, sir?
The other page as well.
Is this the 5-day notice or the document attached?
That's the notice of the POS.
That's the proof of service there.
Are you familiar with the rules of process serving?
Unintelligible, Your Honor?
We couldn't hear, here you go, sir. We couldn't hear what you said, ma'am. Can you please repeat your question?
Are you a registered process server?
Yes.
And so do you agree that you are familiar with the process serving rules
Yes.
or regulations? I ask my question?
Yes, please, go ahead.
Does that make you, are you familiar with the rules of process serving in California?
For the third time, yes.
Not for the third time, just answer the question, sir. Please don't argue.
I apologize, I didn't.
No, everybody's doing fine, everybody's doing well. Just don't argue with the person asking the question. Please ask your next question, Mrs. Steinglass.
Okay, what method of process serving did you serve the documents on 321?
I posted the notice on the door.
You posted a notice on the door?
Yes.
What door?
The door, when you're going up there, there's one door. There's a door, it's a old wooden door, which that's the only way to get into the property.
At the edge of the property? On the street?
Say that again?
Ms. Steinglass, Mr. Steinglass has stated that there was a Ring doorbell that recorded this witness doing everything on March 21, and Mr. Steinglass asked a number of questions about the activity of this witness on that date.
Yes.
So I just wanted to remind you what the state of the evidence is. Asking him to describe the door would be appropriate if you wanted to argue that he wasn't there that day. But I heard Mr. Steinglass testify that there was a Ring doorbell recording him being there that day. So you may ask any question you'd like. I'm not cutting you off, but I wanted to remind you that your husband's already established that there was a Ring doorbell recording this witness' activities at that door that day, and when the witness said he had pricked his finger and was bleeding, your husband stated that he remembered that. You may ask any question you like, ma'am. Please go on.
Okay. Thank you very much. I appreciate that. The reason I was asking because
You don't have to state the reason. Just ask your next question, please.
Okay. Did you get approval from the court to file substituted service as required by Civil Code procedures?
Your Honor, that's not
Excuse
relevant.
me, is that an objection?
Objection relevancy, Your Honor.
What's the relevance, ma'am?
Well, he's saying that he posted it on the door, and that isn't necessarily personal service.
Are we talking about the summons and complaint, or are we talking about the 5-day notice, ma'am?
Well, all of them, and in particularly what instance would be the 5-day notice to complaint, but as to all of them, they were all posted.
Mr. Winsky?
Your Honor, they've entered into this lawsuit. In fact, they barged into this lawsuit originally and were added themselves to the case. The issue regarding service of the summons and complaint is not before the court.
It is. It was an element you established, you sought to introduce by calling this witness to show that the 5-day notice was served. Isn't that an element of your case?
You misunderstood my statement, Your Honor. I said the issue regarding the service of the complaint, the summons and complaint.
I agree, but we're right now talking about the service of the 5-day notice.
I'm moving back to that question.
Oh.
As to the issue of the service of the 15-day notice, the 15-day notice can be served by posting and mailing under 1162. Doesn't require personal service.
Isn't this a 5-day notice?
I'm sorry, 5-day notice. My brain switched over to the other kind of case. Yes,
And it doesn't
5-day.
require an order to post.
Does not require an order to post.
That's why I said to her, there's a difference between the rules regarding the summons and complaint and the rules regarding the notice.
Correct, 1162.
The objection is sustained. The 5-day notice does not have to be approved by a judge to be posted.
Can I I learn the civil code on that matter? I'm unfamiliar.
Nope, just ask your next question.
Okay, understood. Now, you said you saw a person that looked like, I'm sorry, give me one second, I'll find it. One moment, sorry. So basically, what did the person look like that you served upon the service for Debbie Murray?
What is the description?
Objection,
I'm
Your
sorry,
Honor.
is your question about service of the summons and complaint?
Yes, it is.
That exceeds the scope of the direct examination. The questions only have to do with the 5-day notice, ma'am. Do you have any more questions on what this witness has already testified to?
What is the name of the 5-day notice on the page of the 5-day notice?
What's at the top of the 5-day notice? What's it called? Is that your question?
Who signs it? I apologize. Who signs it?
Objection, relevancy?
Overruled. You can answer.
Well, what, I didn't,
Oh,
I
I'm
can't
sorry.
hear her.
Objection, relevancy? Oh, relevancy is overruled.
Okay, as to, well,
Do you know who signed that document, sir? The 5-day notice?
The 5-day notice, who signed the document?
Yes. Do you know? Or do you not know?
I don't know who signed the
See how
document.
easy it is? The answer is he doesn't know. Next question.
Okay. And then, what was the description of that you were given as to who you're supposed to serve?
objection, Your Honor.
What's the objection?
The objection is lack of foundation, relevancy, and...
Relevancy objection is sustained. Next question, please.
Okay. Why did you post the document and then come back and replace it with another one?
Objections to states of fact not in evidence.
Sustained. The state of the evidence is he posted the document. Next question.
Okay. Well, from my record.
No, we're not arguing it. Ask your next question, please. The case will be with the defense, and you'll be able to ask any questions you want of any witness. Next question.
Okay. What happened on April 8th?
Objection, relevancy.
What's the relevancy of that, Ms. Seidenglass?
That's where he pricked his finger, the day that he pricked his finger.
Then ask him that question now.
Okay. What day was,
What day did you prick your finger, sir?
The first time I went to that property.
Thank you.
Did he say the first time?
That's what he said, the first time you went to the property.
Okay, the very first time. Okay. So you're telling me the first time that you went to the property was on April 8th and not March 21st?
No.
Objection, not within the scope of the evidence. Say it.
Overruled. Witness is answered. Ms. Seidenglass, do you have any further questions?
I think, yes. I don't really do
felony charge?
Felony charge. There was no felony. You're the one.
Telling you right now.
Uh,
Letting you know that.
Okay.
You're
Well,
an accessory.
I'm just gonna have to talk to my lawyer then.
Can you answer that yes or no, sir?
No.
Next question, please.
That's all for now.
Thank you for your testimony, sir.
Thank you,
You're excused. May the witness be excused?
Yes, thank
Thank
you for
you.
coming, appreciate it.
Thank you, Mr. Penoyan. The case is with the plaintiff.
Thank you. At this time, Your Honor, plaintiff would rest and move Exhibit 1 into evidence.
Any objection to the receipt of Exhibit 1, Mr. and Mrs. Steinglass?
What's the title of Exhibit 1?
5-day notice
5-day notice
and proof of service.
and proof of service. Mr. Steinglass, any objections?
I object it was not served.
All right, thank you. Noted, and the document is admitted. The case is with the defense. Mr. Steinglass, please call your first witness.
All right. I'd like to call Paul Bowers to the stand.
I'm
Paul
gonna-
Bowers still on the line?
I'm going to object, Your Honor. It was not on a witness list.
Just a moment, Mr. Steinglass, is Mr. Bowers on the witness list?
Yes, he is. I have, yes. All my witness list has been for the entire time I've been here.
Did you send the plaintiff your witness list?
I did.
What date?
3 weeks ago. I get to my computer just a split second. If you want to wait 30 seconds, I can.
I do. I'm going to need to know that you served the plaintiff with your witness list showing Mr. Bowers on your witness list. You have a copy of the witness list you received from them?
We did not receive a witness list, Your Honor.
Have you received anything
I
from
can
them?
send it right now.
We said wait till the noise cleared, Your Honor. Yesterday, we received a stack of exhibits and a email address to look at, which turned out to be a bunch of Ring videos. That came after noon yesterday.
Is there a witness list?
No witness list.
Those videos have been published for
Mr.
over a
Steinglass,
year.
Mr. Steinglass, have you served the other side with a witness list?
Yes, we have, sir.
When did you do that, sir?
3 weeks ago, and then again today, and again in previous filings. It won't be what? I'll send it to you again if you'd like to see it.
What will Mr. Bowers be testifying to?
Mr. Bowers is a member of the Echo Park Neighborhood Council at 3C until recently, and he's a handicapped individual who rides a gyroscopic wheelchair up and down this. In his doing so, we've made friends, and he also made friends with the plaintiff, of course, living on the block, and he is witness to being strangled by the plaintiff's husband, Richard, and contractor on a video that Richard decided to share with him out of whatever reason or logic, I don't know, but he shared it with Paul and this other man named R.J. Smith on the block also for 20 years. And Richard realized that basically we are a neighborhood and a community that stands united and won't be allowed. You can't kill people. You can't step on their property and strangle them. And so he's supposed to speak to the test of watching the video. I apologize for being excited. It just makes my blood curdle.
The testimony of Mr. Bowers will be disallowed. It's not relevant to these proceedings. It would be relevant in an action for personal injury against the defendant for the alleged injury that Mr. Bowers would be a witness. That will be my order. Mr. Seidenglass, your objection is noted for the record. Mr. Seidenglass, I'd like you to identify the list of witnesses that you have.
Yes, Daniel Resch, Berman.
Let's go through them individually. Let's go through them individually. What's the next name?
Daniel Resch.
How do you spell Resch?
R-E-C-H.
And what will Mr. Resch testify to?
Seen everything about our living here since the very beginning, and he's another member of the Echo Park neighborhood, and he has good upbringing, and he just wants to.
Will you be testifying as to what date you started living there?
I'd be glad to.
Is that anticipated testimony you plan on presenting? Your testimony as to what day you began living there?
I would have no problem doing so. I've already done writing. I don't mind.
All right. If Mr. Resch is going to testify as to what day you started to live there, that would be duplicative of your testimony, and therefore he will not be allowed to testify. I will hear from you, however, with regard to any testimony you wish to make. Do you have any other witnesses?
There are, but not exactly available at the moment because of...
Would you like to testify, Mr. Seidenglass? If your witnesses are unavailable, would you like to testify now?
Yeah, sure, why not?
I don't know why not. I'm asking you if you want to testify. I'm not trying to have a discussion with you. I'm trying to conduct the trial.
I would like to be able to share the videos that directly reflect on the whole case. That's my primary goal, but whatever I need to do, I'm here to tell the truth.
Mr. Seidenglass, would you like to testify?
Yes, I would.
Let's swear the witness.
Over here.
Mr. Seidenglass, can you hear me, Mr. Clerk?
Oh, yeah.
Okay, I need you to please stand and let me know when you've done that.
What was that?
I need you to stand up, please, and let me know when you stand up.
I'm always standing. I'm already standing, sir.
Okay, I need you to raise your right hand, please. Is it raised?
It is.
Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. It's 100% God,
Okay.
and I believe this is the truth, 100%.
Okay, I need you to please state and spell your name for the record.
Eric, E-R-I-K-S-E-I-E-N-G-L-A-Z as in zebra.
Thank you, Mr. Seidenglass. You may testify.
Sorry to interrupt. I thought I heard it said I wasn't available for a witness. Daniel Rush.
Mr. Rush, you've been released and you're no longer required to testify as a witness. Thank you for calling in.
Yeah. Okay. Bye-bye.
Thank you. Mr. Seidenglass, you may proceed.
I have a question. How do I testify to myself? I'm just asking quietly.
You're under oath, sir, so anything you say is testimony that I will consider under oath. What would you like to tell me about this eviction?
Well, my tenure here started in 2016, officially on November the 9th, the day President Trump was elected. My wife had been here prior to that even, which stated in our background reports that are public record. Her dates back even to 2012, even though it wasn't continuous at that point. We both started our continuous stay consistently on in 2016. However, there are many records, different things going on in this property. There is no record except for Ruth and Tina. I can't hear anything. Sorry. The one thing that I would really like to have been able to let the court hear is that Daniel, who I am friends with, has actually met the prior owners personally because we somehow managed to miss them. And upon walking into my house, he had a long conversation with the owners of 30-plus years.
Mr. Seidenglass, please testify to what you have personal knowledge of, not what anyone else told you.
I understand. It's on the ring as well, but I will continue without any drift. I'll stay on focus path for you. So anyway, my wife and I had been going through tremendous difficulties because of her narcolepsy type 2 and my bipolar 2, which we are both art school students and professors, and we've basically been made homeless in San Francisco in 2015 due to the rent increase that was massive, and we were Ellis evicted, and that's where we cut our teeth on learning about an Ellis eviction. And at which point moved to Arizona and rebuilt our lives and moved to Los Angeles, and by November 9th, like I said, we had won the Robert Rauschenberg grant for change Inc.
For
from
the
Robert
record,
Rauschenberg.
I would like to make a 352 objection.
Mr. Seidenglass, that objection is sustained. Mr. Seidenglass, please direct your testimony to the issues in this case, not any awards
I'm going-
or what you studied.
Yeah, I understand.
No,
It's how we ended up getting our...
Mr. Seidenglass, please let me speak. I'm going to allow you to testify by giving a narrative, but please slow down and please direct your comments to the issues in this case.
You got it. Anyway, we completed our first possession for the most part, around 4.5 years of it, and that's when the Shapiros had sort of made themselves known by this thing called title lock. Title lock is a service that you pay for that will announce when your title has been hijacked by someone. It's sort of a gimmicky thing, but it's by a former FBI agent who runs this company. We signed up for the service because not knowing that much, but in 2019, our family, Alicia's father and mother and sister, came to our house for Thanksgiving with her other mother-in-law, because her dad is married twice, and told us about this service and that we should actually use adverse possession to our advantage because it was a good thing, because we had done something that was the all-American way. And a Latin family, which Alicia's from, actually has a lot more Americanism built into them in their psychology in the first place than we do usually, because they're working so hard to live up to the standards of what we told them America is. So I got a lesson on Thanksgiving about what America is from a family that's from
Mr. Seidenglass,
Chile.
Mr. Seidenglass, you're doing it again, sir. Please direct your testimony to the issues in this case.
I am focusing it, Your Honor, I promise you. I will really wrap it in. Just let me have this little bit of leeway to at least establish the picture of where we were.
No, there's no picture of where you are. Just get to the point.
Fine. Anyway, Thanksgiving was spent here with her entire family.
No, you're picking back up to Thanksgiving. Get off Thanksgiving.
Well,
Let's get to the issues in this case, sir, please.
the date of Thanksgiving is 2019, and we were here, and we have photo proof. And that allows us to be here because we were also here in 2017, which I have photo proof of. I have gardening proof. I put over $200,000 at this point in Home Depot trips, which Daniel Resch was going to testify to because he's been my ride with his van. I have the receipts for it. I have proof of the actual work, and I have a homeowner's exemption from 2019 in November. I also have 610B3 IRS tax the declaration. 610B3 IRS code is, or Internal Revenue Code, is one that states if you demand to be on the tax roll, then you will not be denied your right to be on the tax roll. And so we never filed one document that we carried, that we had notarized in December of 2019, called a petition to preserve interest. The petition to preserve interest is a formal document used to preserve one's interest. And we did not record it officially until recently, but it was notarized at the aforementioned date in late 2019 in December, and was noticed by the recorder and then sent back to us because of needing an extra piece of information that would coordinate it. We were given a temporary number, and we've been in the hold ever since with the temporary number, waiting to hear back, yet never hearing back from the assessor.
Your Honor, I'm going to object at this time on relevancy grounds and move to strike.
Overruled. Go on, Mr. Seidenglass.
Then waiting for a response from the assessor forever, we finally get a response that says that we need more information to coordinate with you whether your ownership is consistent. We had already filed the homeowner's exemption for the year prior and had begun a nonprofit with a business license at this address with the City of Los Angeles and the federal government in 2019 on March 16th. That's been approved and acknowledged by both departments that I just mentioned. I would consider that prima facie if I'm not correct, I could be wrong, but the Office of Finance and the IRS both acknowledge this is our primary address for our business, Harlow Hamilton Harris Fellowship Parkway Conservancy, whose actual articles of incorporation specifically explain our purposes of giving back the remaining outer lands of our property for conservation to specifically protect and create a open space environment that would allow the future generations to actually have a botanical garden in this park. And we have since become one of the only wildlife reparation bird sanctuaries legitimately allowed in Los Angeles for hummingbird, restoration of habitat. And we're actively seeking, grants and things to run this because this is a bird sanctuary. At the top of the park is the oldest bird sanctuary in LA. I'll stop the bird sanctuary tangent, but the thing is we wholly committed ourselves to something based on one piece of knowledge that was in the middle of our adverse possession. When we started to understand it, we were reading all this law from Harvard and the case law on and case text on it, and it was stating that environmental critique as adverse possession is a concept that is usually forgotten about, but it allows people to oppose adverse possession in the traditional sense of acquiring land by property flipping, which was introduced by judges in the 1890s or earlier to introduce people to the West because the we call that the Lewis and Clark Louisiana Purchase, and to influence things more like John Muir, and that ironically that the things like John Muir and protected habitats were at a loss due to their lack of fencing usually, and that we now...
I really need to object on the grounds that this is, number one, not relevant, number two, it's outside the scope of this court's jurisdiction to deal with this issue.
I think this is really the point on...
Please conclude, Mr. Seidenwald.
Absolutely. So it was in our minds that we don't know what we're doing other than we're trying to do it right. And so this gentleman named Stephen DiCaprio, who's been to the, I believe the Supreme Court and to the Alameda County Board of Supervisors Court for a $800,000 trial against him and 4 others. They were called like the Oakland Five or something. He basically showed us the way and the light of being completely steadfast in the center of the law and never ever wavering from anything other than the absolute...
Excuse me, the hearsay objection is sustained. Please don't testify what someone else told you. Please continue, Mr. Seidenwald.
He taught me, didn't tell me.
Please don't testify please don't testify to what someone else told you or you overheard. Just what you know.
It was a self-realization within myself that you must be basically 100% dead on with the law because that's the only thing that will be right is the just. Because there's no other way. Because adverse possession is the only thing that you cannot be accused of for mortgage fraud in a purchase of a property if there is like arm's length transaction problems going on. An adverse possessor is not a suspect.
Objection, legal conclusion.
And this is something that we came to learn. FBI's website. It's literally on their website, verbatim.
Objection,
adverse possessor is
Mr.
not.
Seidenwald, I've asked you not to testify to what other people told you or what you've read on the internet. Are you ready to conclude your statements?
To a degree, yes.
Please continue.
We would like to, yes, give me 1 second. Thank you. The number of times we've been visited by the LAPD during our time here has been over 21 times, which is ironic because no one would give us this record until finally we wrote a long enough clause to get our record request fulfilled, and a simple enough one that didn't request anything other than the bare data. We also found all our business cards that specifically addressed what the issues were when the police officers showed up. The typical call was that of a harassing incident claiming squatters, but the business cards always stated one thing. They always stated, I'll read them for you.
No, Mr. Seidenwald, please don't read what someone wrote on a card.
Okay.
That would be hearsay.
Well,
Please
okay.
conclude your comments, please.
Well, fine. So I was in...
No, don't tell me what someone wrote on the card, sir. Please continue.
All right, well, I'd like to introduce the card somehow through a visual presentation if I would be allowed. But anyway, the police officers basically gave us knowledge that we were being called so much that they were being harassed, and that would be good of us to...
Mr. Seidenwald, I've asked you not to tell me what the police told you. Now you told me that they told you they were being harassed. What the police told you is hearsay. Please continue.
All right, well, Officer Geikum came to us directly to tell us that he was going to put a stop to it because
No,
of his
I asked
harassment.
you to please not testify what other people told you.
All right. Well, anyway, my wife and I have been here for such a long time that, like, yesterday I spent $1,000+ the day before I did on gardening. I have been doing this consistently I have the receipt for it, for the last 4 3/4 years, if not a little bit more. I'm not sure I'd have to Google how many days it's been, but staying here that long has been an arduous task. And what happened really is that in 2019, we were surrounded by a group of contractors and gardeners who came up through the backyard after breaking our fence down, came up the back stairs, and specifically said they were going to put a fence around us. I said, what are you doing?
The
Why?
relevance objection
Not right.
is overruled.
It's a very important moment. They tried to surround us with a fence, and they told me they were going to put it around my property, Harvey's property. Harvey Shields lives above me, or has the ownership, and the one next to me, Darius Sherman, and then the one that is opposing to Darius Sherman is Richard Judson Williams and Cheney Shapiro. They own the house 2 doors over, and that's when it kind of dawned on me why we were getting messed with, because we were being messed with by these gardeners consistently and contractors, and they were laughing at us and telling us like funny, mocking things whenever we would be outside at the same time, and sort of taking a laugh at us like, oh, that's what Americans do. And so we finally realized this is literally their influence because they work for Judd, and it shows so on the camera. We didn't know that. Judd is Ken's husband, and Resourceful Construction, of which is a contractor who has no license and has not had one to operate effectively since 2015, and has been running against the stop orders.
Lack of foundation objection is sustained.
Anyway, he is asked them to fence us in. I tell them no, and Elizabeth stands her ground and says, you have to put the fence there, and we show them the actual property line, at which point they put the property fence for Darius Sherman in between me and Cheney on this proper location, and did not surround us any further.
Mr. Seidenglanz, please explain how this fence is important to your case.
A fence is everything. A fence is showing exclusivity.
No.
Specifically,
How is it important to your case defending this unlawful detainer? What element to the defense or element of the please let me finish. What element to the cause of action or element to an affirmative defense does a fence have to do with?
a fence is an exclusive right and done something required in my prescriptive control over my property, and I specifically predate their claim by the 5 years. And their claim is also in a fraudulent transaction where there's no money exchange between lending home and Lansing Investment.
But you don't have an adverse possession claim in this case. There's no counterclaim in this case.
I do. I have it filed. I literally have it filed multiple times. It's my very first filing, and you guys keep on just not acknowledging it. It was filed with Peter Gordon, a lawyer. Paid a lot of money.
Please continue your argument, but focus on the issues in this case, please.
I filed opposition to the argument in support of, opposition to the ex parte special appearance.
Sir,
Very first filing.
Sir, there is no counterclaim in this case.
And I make the counterclaim wholeheartedly that this is not accurate, that like I have a counterclaim. It is that we commit adverse possession first and foremost, and it is absolutely shown on video. I have 5 years of video.
No, Mr. Seidenglanz, please listen to me. In this case, there is no counterclaim allowed in an unlawful detainer case. You do not have a counterclaim in this case for adverse possession. I'm not asking you that. I'm telling you. Please conclude your testimony, but please don't continue to testify about adverse possession. That's not relevant to this case.
All right, you got it. I'll take another approach, you know. November, wait, what was it? March the 8th? April 8th, which is 4/8. 4/8 is April, correct? I'm double checking here. 4/8. Okay, so on 4/8, that's when Tannis Tanyan shows up. I can go exactly when and who shows up when and where, and I would be more than obliged. I would prefer it if you guys would just watch the videos, a few of them. I place them on the website and on a playlist for your easy listening, if they're not that long. If you were to take my remaining time available of any length and apply it to that, it would allow the visual to present what you're going to be continuously frustrated by with me. Like
I'm not frustrated, Mr. Seidenglass. I'm merely making rulings. Ms. Seidenglass, are you ready to testify?
Yeah, I'm right here. Oh, her?
Yeah, is she ready to testify?
Sure, am I done? 'Cause I was on
I thought you were finished. I thought you said the last thing you wanted was for me to watch the videos.
Yeah, I do. I wasn't sure if you're acknowledging it.
I'm going to acknowledge that in a moment. Let me hear from Ms. Seidenglass then. Thank you, Ms.
No
Seidenglass.
problem. She'll be right here. She's just over from the other side. Be right over there. Thank you.
Thank you, sir. Have you sworn, Ms. Seidenglass?
No.
We're about to swear.
Tura, are you there?
Yes.
Okay, could you please stand and let me know when you stood up?
I'm saying,
Please raise your right hand and let me know when your hand's raised.
yes, my hand is raised.
Do you solemnly state that the testimony you may give and the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, I read.
Okay, what I need you to please state and spell your name for the record.
Elisa Seidenglass, ELISHAPIRASEIDENGLANZ.
Thank you.
Thank you, Ms. Seidenglass. What would you like me to know about your case?
I'd like to point to the motion for some judgment filed on January 27th, 2021, in which the Judge Upinder Escala made a ruling in which that resulted in a denial of the summary judgment due to plaintiffs not establishing compliance with the elements of Civil Code Procedure Section 1160. And basically, what it states is that, and we recite the CCP 1160, that every person is guilty of a forcible detainer who has by force of admitted or threats of violence unlawfully holds and keeps the possession of any real property, whether the same was acquired peaceably or otherwise, and two, who in the nighttime or during the absence of the occupant of any land unlawfully enters upon real property, and who, after demand made for the surrender thereof for the period of 5 days, refuses to surrender the same to such former occupant. And the occupant of real property, within the meaning of the section, is one who within 5 days preceding with unlawful entry was in the peaceable and undisturbed possession of such land. So, as the Ed's testimony, as well as mine now, we clearly hold that we have held actual possession prior to the complaint made by Cheney Shapiro, which I assume is that she, as he states on the, as the attachment language in the statute makes clear, the plaintiff cannot prevail on a cause of action for forcible detainer unless an unlawful entry has occurred, sort of Mrs. Talbot, where forcible detainer found where entry was without consent. And,
I'm confused. Is this testimony or just reading the law?
I'm sorry, I couldn't hear you.
I could not tell if this is just reading the law or if this is testimony.
Are you about to testify to facts, ma'am, or are you just reading the law to the court? Because I know the law, you don't have to read the law, but I wanted to hear if you had any facts you wanted me to consider.
I'm sorry. Yeah.
All right, let me hear from you. Put down the law and just tell me what you want to tell me, ma'am, please.
Okay, basically, we have been in actual possession of the property, and we are also entitled to the possession of the lower unit because of our consent to Section 325. We are, which we, what's it called? And all the facts that the plaintiff Cheney Shapiro and Long Plateau takes on are all stories and events that happened at different times. For example, the day that photo is taken in Exhibit 5 that we talked about earlier is actually the day that the
Objection on Exhibit 5, I don't know what you're speaking of. Like
Exhibit 5. The only photo that was
Objection
provided
sustained.
in the exhibit that it's the aspect of the possession and exhibit. And so, sorry, one second. On March 13th, executive orders by Governor Gavin Newsom came into effect due to the coronavirus.
Ms. Seidenblatt, you're doing it again, you're reading the law. Is there something you want to testify to about facts that you know? Don't read me the law, just tell me what you want to tell me about the facts as you know them.
I understand. I am actually stating the fact
Don't
that
read
the
me
legis-
law, don't tell me what the governor has done. Tell me about your tenancy, ma'am, please.
Okay, so during the coronavirus, they came, Cheney and Judge appeared on our gate stating things like, go in there, we're gonna just cough, and then we'll take it from there, and then they start using tools to undo the fence line, and the door to the fence line. They call it barricaded, but it was actually locked, just locked.
Captain Relevancy, Your Honor.
Overruled.
There are multiple entrances on the property as well, and so for them to say that it was barricaded is inaccurate. And then what they did was go around to the lower unit and find the fence that was two fences, and then came onto knocked on our door, and this is all under the pretense of a notice of intent to inspect the property, which I believe they did not file with the court, and that was also filed on posted on our gate the day before. And so when they are at the gate, they're saying that they're the landlord, that they have new orders, or landlord, and that they came and inspect the property. But would not give out their names. They refused to identify themselves, and they were pounding on the door really loudly, and also video recording stating that we were being hostile, when in fact it was dead, and the third party, who I assume maybe an appraiser, is with them. We're being hostile towards us, and we're very concerned for our safety. We called the police, and the police didn't show up for another 2 hours, and they as soon as they heard me calling, they ran down and left the building. That was the first. That was one of the first incidents, but so this happened right as the coronavirus shut down. It happened, and the court, on its own motion, filed extends the order to show cause for failure to file proof of service to August 29th. It extends it from July, I forget the date exactly, but to August. And then, so this gives plaintiffs a little bit of time to reconsider the circumstances, and under the new emergency orders, like there were the judicial council said that there would be no unlawful detainers for.
Your Honor, I'm going to continue to object.
Ma'am, I've asked you not to tell me about the law. I'm hearing from your testimony. It sounds like you concluded your testimony. Are there any more facts that you want to testify to?
I'm definitely not done.
Ms. Seidenblatt, please,
Yes?
this is the 4th time I've reminded you. Please testify to facts, not about the law, ma'am.
Possible, thanks. Okay, so other instances, they used a drone to spy or to get a view into the property and then circled around the house multiple times. And while we were in the house, and let me tell you, that was probably the most terrorizing feeling I've ever felt.
Objection, relevancy, Your Honor, and vague as to time.
Overruled. Please continue.
And that I could prove on video as well. On another note, they removed called a protected tree called the Mexican elderberry tree and its root ball system. They removed the historical staircase from the property next to the Avon as well, and installed a really weird not up to code without a handrail staircase right to the center and a half through it, and then
Objection, relevancy, Your
and
Honor.
also
Sustained. Thank you for your testimony, Ms. Seidenblatt. You've been testifying now about vegetation at the property. How is that relevant to the case, Ms. Seidenblatt?
Because we take really good care of the landscaping here, and
Okay.
we've been started working on it for a long time, and so it was really like.
So I accept that testimony, ma'am, that you've taken good care of the landscaping. Do you have any other testimony you wish to offer?
Yes, I do.
All right, please come.
Okay. So this case, this case is based on all entirely on false claims because they filed. Okay, what happened?
Ma'am? Ma'am?
Yes, I understand.
Ma'am?
Uh-huh.
Mr. Seidenblatt, are you there? Mr. Seidenblatt, are you there?
I can hear you barely. Yes,
Then come closer, Mr. Seidenblatt. This is very important.
I'm paying very close attention. I'm just trying to sort the videos to make sure that this is, all right, I'm trying to hear you. Got it. Never mind.
Mr. Seidenblatt? You are in danger of being held in contempt, sir. I am now putting you on notice. If I hear your voice again while your wife is testifying, that would be a violation of the order I'm about to give. I'm ordering you not to talk to your wife while she's testifying, not to gesture to her, not to show her any documents, not to communicate with her in any way. Do you understand and acknowledge my order?
Absolutely, and I will absolutely hold to that, and I'll go outside for a minute.
I want to hear you quiet as a mouse, sir. Miss Seidenblatt, you may continue testifying, ma'am. Please continue.
Okay. And then
Have you concluded, Miss Seidenblatt?
no, I have not.
All right, let me know. Go ahead and finish, ma'am.
They pursued to take over the bottom building by using tractors and excavating the land, and then they erupted the septic tank and caused a lot of damage to the property, and all the while
Objection, relevancy is
and,
another property.
with their employees, 13 men strong, in fact. In one instance, we had a volunteer helping us landscape the yard here at 1410, and all of a sudden, the volunteer I see running towards the house at full speed, and I'm wondering what is wrong, and then I see 13 grown men chasing after him. Claiming that he threw rocks at them, and then Judge following up with them calling the police, saying that Eric was throwing rocks at him when Eric was never in sight or was
Objection,
sitting down.
hearsay, and relevance both.
Sustained. Miss Seidenblatt, what does this have to do with the lawsuit?
They are constantly making up these stories in order to meet the standards of a public health and safety issue because of the...
There is no public health and safety issue here, ma'am. The landlord is trying to evict individuals in their property. If you have a defense, if you have testimony relevant to a defense or relevant to the issues in this case, which do not have to do with adverse possession or landscaping. Please
Okay.
conclude your testimony, ma'am.
Yes, I will conclude. I understand. Yes, so basically, I want to conclude with that the defendants I want to conclude that we were here way before Cheney Shapiro or Long Black Co. ever stepped on the property or lived on the property. Cheney Shapiro had testified that he knew about us prior to making the purchase, and therefore he doesn't actually meet the elements of forcible detainer actions, and so their complaint actually does not state
Objection,
a
legal conclusion,
cause
Your
of
Honor.
action, and that so because and also that they state that they had an entitlement that at the time when I was absent and without my consent that we entered in between the dates of February 24th and March 4th, we had already been here much longer, and so all of these claims are made up, and we have evidence showing that, and that is all.
Thank you. Any cross-examination?
Just a couple of questions, Your Honor. Ms. Seidenglantz?
Oh.
Ms. Seidenglantz, did you ever pay any rent to any of the owners at 1410 Ewing Street?
We run, we did initially with the city, and we've also...
Ms. Seidenglantz, the question was, have you ever paid rent to the owners, not to the city, to the owners?
Oh.
That's a yes or no question, ma'am.
Can you define the owners?
Did you ever pay any rent to Mr. Markison?
No.
Did you ever pay any rent to Ms. Shapiro?
No.
Did you ever pay money, anything to the bank?
No.
Thank you.
What is the thing?
Thank you. No further questions, Your Honor.
Thank you for your testimony, ma'am. Can you have Mr. Seidenglantz rejoin us? I didn't allow any
I
cross-examination.
was going to come back to that, Your Honor.
Please have Mr. Seidenglantz come back into the room.
Okay, one moment.
Mr. Seidenglantz, let me remind you, you're still under oath. You're subject to cross-examination by plaintiff's counsel. He's about to ask you some questions. Please listen carefully.
Mr. Seidenglantz, did you pay rent to Mr. Moccasin?
Mr. Markson is not my landlord, so no.
Did you
Mr.
pay?
Seidenglantz, oh, the answer was no. All right, the answer will stand.
Thank you, Your Honor. Did you pay any rent to Ms. Shapiro?
No, I'm actually allowed to use HCDLA.
Did you ever pay rent to the bank?
The bank hasn't even paid for it.
Are you able to answer that question, Mr. Seidenglantz? Yes or no? Are you able to answer?
I don't deal with ProSci. I never paid that bank, the Lending Home Funding Corporation, because they specifically steal title, which is quite clear in this bifurcation of the title.
Mr. Seidenglantz, the question is... Mr. Seidenglantz, you're interrupting me. Please, sir. Mr. Seidenglantz, did you ever pay any money to the bank? Yes or no?
I don't have a mortgage, no.
Thank you, sir. Any further questions?
No further questions, Your Honor.
Thank you. The matter is now complete with regards to testimony. Mr. Seidenglantz, any further witnesses after your wife?
I would like to at least add one thing to the record.
No, any further witnesses first. Let's conclude this aspect of it.
Is court nearing its end for today? Because I would like like to make.
No, I'm asking you if you have any further witnesses, sir. That was a yes or
I
no
do,
question.
I do, but my
Then
neighbor
call,
is still probably 10 minutes.
then call your next witness, please.
Isabel, Buckley? Is Ben? Are you there?
For the record, Your Honor, we received a declaration from Ms. Buckley, which we were going to object to if it was introduced, but she's not on any witness list we have.
Is she on the witness list, Mr. Seidenglass?
Yes, she is, absolutely. We wouldn't be so foolish as to...
Tell me what day the witness list was filed with the court. I don't see a witness list for you, sir.
My wife is double checking so that we can check. She said it was filed with the plaintiff and it was filed, I know it was filed with the court because it was filed with the court first. Jacqueline is my wife's name. 1 second. You need to verify. Give me 1 second, sir. It was the first document that we submitted, basically, that was...
All right, I reviewed the declaration of Isabel Buckley. She will be disallowed as a witness. Her testimony is not relevant to these proceedings.
Well, why is not? We have it on the witness list.
I've reviewed her declaration that you filed with the court. It doesn't appear that there's any relevant testimony here to the issues in this case. Mr. Seidenglass, is there any fact that Ms. Buckley will testify to that is a defense to this unlawful detainer case or goes to any of the issues in this case? If so, please identify what issue the proposed testimony goes to.
1 year to the date of being here, we are guaranteed an interest in our property by acknowledgement of a court if we seek it. This was something we were already seeking with our own quiet title, which ended up us spending money on this instead. We've already been doing 5 years of research to find out what happened to this property before the Shapiros. Because before the Shapiros was actually a much bigger fraud than they are, and we specifically have been chasing it down. Our neighbor has been chronicling the entire time and seeing that we have made it through this. She's also seen what's happened to us, and specifically knows that we've been here more than a year and would guarantee us an acknowledgement of our interest. She can guarantee 2 years. She can guarantee 3. She can guarantee 5. That's what's amazing, is that our neighbor became our friend because of what we did to the neighborhood. Everyone said we opened up a view that had been closed for over 30 years. And we brought back community on a street that had been sort of closed off through Gang.Judge.
Thank you. So you don't have any other witnesses other than Ms. Buckley?
I have several, but you're going to take 5 minutes to get one of them on the phone, because I'm pretty sure that's this long of a court, like, waiting, that they hung up and would be glad to come right back on if they just knew. I don't have any
What would be the,
at all.
what's the name of the witness and what's their proposed area of testimony, sir?
Jenny Bauman. Jenny Bauman is a writer and professor, and she would lived on the block and has for many years, and she would testify to the nuisance that the Shapiros actually are on this block rather than the nuisance that we are not.
Thank you. Nuisance is not an issue here. She will be disallowed as a witness then. We'll now proceed, excuse me, we'll now proceed to argument. Plaintiff.
Thank you, Your Honor. The evidence before the court is that my client is the owner of the property and learned upon purchasing the property that there were people occupying the premises. A notice was given to them, 5-day notice to vacate the premises. They haven't vacated the premises. They're still in possession of the premises. As I indicated in my opening statement, we're not seeking monetary damages, we're just seeking possession. I would point out to the court that if the court believes the testimony of the defendants that they were there for more than a year, and I don't think they presented any evidence that support that, but so be it, then the court has the power under CCP 1173 to amend the pleading for another unlawful detainer, and I would suggest that if they're not forcibly detaining the property, they are clearly what we would call tenants at will under 789.
We're not amending the complaint. at the end of the trial.
Like, as a matter of fact, the court should and can under 1173, Your Honor,
Just
specifically.
a moment, let me review that.
Please, so the court would. We have to wait till the testimony is before the court to be able to do it.
So your amendment is what?
If the court finds that we are unable to prove, and the court will weigh the evidence, so if the court finds that we did not make a clear enough showing for forcible detainer, we think we have, the court could consider my plea to amend the complaint under 1173, and the evidence that's before the court is that these people have not paid rent and they're in possession of my client's property, which would be under Civil Code Section 789, and therefore my client should regain possession. We're not seeking any money.
Mr. Seidenglantz, I'll hear from you on the issue of amendment, please.
I object, Your Honor, and that typically it's on 4/26/2020 that the property was reconveyed only after going to a title insurer who only insured the loan, not the property. This was because he transferred as a reconveyance until it had cleared that, meaning that none of the filings that they have made whatsoever had actually been with any standing at all. Even when it's transferred to Marketing, it happens about a month later, which is noted in the title transfer report, the full title transfer report, and was in REIT and was an Ellis active house. There was no way for the transaction to happen. The bank just takes it and bifurcates it because they want to steal their house back after they've already abandoned it. And it was completely a securities bifurcation that would not hold water. There is nothing about this title that holds water.
All right, thank you. The court will allow the amendment. The complaint is amended to add a cause of action for unlawful detainer pursuant to CCP 1173.
How is that justice?
Please conclude your argument, Mr. Winston.
Thank you, Your Honor. So under either cause of action, my client is asking for possession of the property. That is to say that there is somebody occupying their property who they don't want to have there anymore. They're not tenants. They're either forcibly detaining the property or they're tenants at will, albeit not my client's will, but they're physically there, and therefore my client seeks possession of the property.
Thank you.
Thank you, Your
Mr. Seidenglantz, I'll hear from you now to summarize your case for me, please.
I would still like to comment on the pleading just made because I have a right to, I believe.
Actually, I don't think he does under that section, Your Honor.
Mr. Seidenglantz, I've ordered the complaint be amended to include a cause of action for unlawful detainer, and you may argue your case now, sir.
I live in a formal RSO until it's otherwise removed from the rental market. The house is still under a 10-year order of Ellis Act covenant. I am disabled by technical terms, however, a high-functioning disabled. My wife is not high-functioning disabled, but is actually high-functioning at writing, at least. We have every right to a year and a half plus under an RSO because of our disability status, and the RSO ordinances would specifically dictate they must notify of a foreclosure proceeding and that there would be a 90 or 120-day supplemental countdown for the tenants, and can be extended a year or a year and a half, I believe, somewhere in there, if they are disabled truly. My wife is completely disabled. But with love, with all my heart, but that's not the point. We have these provisions extended to us, too, because we have umpteen REAP certificates that have been sent to us over the years, of which we have turned in several, but unfortunately, it's not that unfortunate because I approve of it, but the plaintiff's lawyer, for Jacqueline Grace Collette, her brother or a family member, close family member, from a former residence that they have the same address on, his name is Carlos Collette, and he is the
Objection, Your Honor.
Overruled argument.
Thank you.
Go ahead, please. Go ahead, sir.
He is the custodian of records for the ACDILA, and since our house has been in REIT for 20 plus years, at random, in October, we suddenly received notice from ACDILA, another employee inside of the...
Mr. Seidenglantz, you're now arguing evidence that's not received during this trial. There's been no trial received about such a letter. Please confine your argument to the evidence received during the trial.
Carlos colludes documents are from the DRC file. They're like public record and they're prima facie.
No, Mr. Seinglass, please, listen to my words. Please only argue from the evidence that was established during this trial, not from any other source, please. You may continue.
Yeah, anyway, the records that we have for our house during our stay here miraculously ended up in the Board of Supervisors meeting for removal from the rental, or for, not removal from the rental market, removal from REIT. Yet there has never been an inspection as stated in any of them, and the general manager would basically, in oral argument, reverse anything that happens now because of the fact that this is a defrauded thing. There's an internal city corrupt act going on between AJ Collet and Carlos Collet. AJ Collet works for LADBS and filed for all the permits. Every permit on this house that they took out, Richard and Cheney, was taken out under an APN ending in 17, which was deleted over 5 or 6 years ago and has not functioned since. And by doing that, they obfuscate the housing department's rules of tenant habitability plan and tenant habitability requirements and relocation requirements as necessary. Yet we were still given a letter by Coldwell Banker to offer us money for a cash received buyout offer exchange. But this was unacceptable because we actually have put in way more than they were ever going to offer, and they have literally made this their modus operandi at Coldwell Banker Beverly Hills. So that's it. She only handles the $100 million properties, and evidently she handles 25 individual properties that have been all forcible break and enter evictions, and we are the only ones to have survived her 25 other cases because we never have left this property. My wife was severely injured when she was basically subject to a trapdoor fall on the bottom property, which was set up for her by Richard Coldwell Bankers, and at the negligence of Richard Judson of Shapiro Cheney, are able to cause my wife to fall down the pole, as can be clearly seen in the very first video that we have to illustrate, in which my wife is forced backwards down a pathway and falls down a trapdoor with a 16-inch piece of plywood covering the trapdoor, in which there was normally no door there because one would want to see the hole. And it was set up to cause her to fall, and she does fall, and this would assumedly get rid of us, but it only causes the Joyce Essex Harvey, Coldwell Banker original broker, to quickly hand off to Ken Shapiro as selling agent, and Ken Shapiro then transfers it to himself through what we saw in title lock, and then that transfer goes to Cheney. There's a missing transfer between the broker, who probably uses a broker buy-out option, which puts this in a very non-harm's length transaction. The Ken Shapiro sells it to his daughter as both broker and buyer, seller and buyer. And then this is because Lending Home can't transfer the property to them until they get a title insurance. They go and defraud the title insurance, which WFG title insurance actually says point blank. We have audio recording, and they acknowledge it, and a writing email to us specifically stating there was no title insurance on the land, just on the loan for 1 day, and then it was canceled because of the fraud.
Mr. Seidenglanz, I've allowed you to argue now matters outside the record. I can't allow it anymore. You've got 3 minutes to conclude your statement. Please start and only argue the evidence. You have 3 minutes, sir.
On the 24th of March, or 26th, the reconveyance that happened by Lending Home is done with a notary that does not have right to notarize the document. The notary is in Texas. You can't notarize on e-notarization for land in California by technical terms. And this other notary has also been in trouble in multiple instances this year for the exact same type of fraud, and is considered a robo-signer by all means, and is listed in a robo-signing directory of DIY fraud, robo-signing whatever. It's a 900-page archive from a case. I specifically cite it clearly right here. The page is the is number 1. Wait, no, not 1. Sorry, give me 1 second. I have to turn a couple pages. It's on a page we filed with you. It's 18 pages long. It's the original title report. From the title report house of choice by the plaintiff. It is the OC title. OC title specifically holds a slightly different set of records than everyone else.
Mr. Seidenglanz, there's no evidence in this case about the title report from OC Title. You've got one more minute to, you've got, Mr. Seidelantz, please don't argue with me. You've got one more minute to conclude your argument, sir.
If you could hear anything, because my life will be irreparably harmed in totality by this. We were homeless once in our life and we earned our way from our bootstraps up in this place. We've been a pillar of the community, even become members in Echo Park Neighborhood Council, and have a large support system, which we started off with none. Now we have everybody on this block as our support. It's like almost 20 people, except for one person who is a friend of the who actually stole our ring and froze it, and we have video evidence of that, and that's fine, but we got over that. That more than anything, Lending Home doesn't have the right to transfer the title. They take it in a quitclaim. A quitclaim is not a warranty deed. The house was not under the proper substitution of trustee when they take it. They don't substitute a trustee. It was originally with American First Title, and they transfer it for Quality Loan Service without any substitution trustee. Quality Loan Service then transfers it to Lending Home's bigger company, Wellington Savings Trust FSB, Christiana Trust, not in its full capacity, but as security holder, and then to NPR Trust 1. Those three entities make up a fragment that is unreachable and cannot be contacted. We still contacted Quality Loan Service on the day of the non-judicial sale. The non-judicial sale was supposed to happen, and they told us they don't care what we said about having adverse possession. We then proceeded to
Mr. Seidelantz, you're again testifying to matters outside the record. You've now concluded your argument. I'll hear from Mrs. Seidelantz. Ms. Seidelantz, let me hear from you in conclusion of the case.
Section 1173 states that the plaintiff, if they find that the defendant is guilty of a forcible detainment, I asked the court that we presented or make. I point to the court that we've evidenced clearly that we did not forcibly enter and did not forcibly detain the property. So therefore, Section 1173 could not be applied because we are not. Those allegations are true, and we've shown with multiple evidence on the record, on multiple filings, stating that there is that we've been here and have the actual possession. That also that there's a defect and a misjoinder with the party, pursuant to Section 410, and then that the so I'm asking, how does that apply?
Have you concluded your argument, Ms. Seidelantz?
No.
Please, you have 5 more minutes, ma'am. Please conclude.
Okay. Basically,
Ms. Seidelantz, thank you for your argument.
I'm sorry, I do have more. Please give me a moment. Just finding my message. We're hoping that we've been in actual possession of the property, and forcible detainment entry only has to deal with objects that are within 5 days proceedings of the claim, be in peaceful possession of the property, which is we are. And Shapiro does not actually have ownership because the title is void, pursuant to Eric's complete summary of the case, and because the title is void, that these are matters that and that's the case number. And so that, and according to Benson versus Guile, if there is an issue of title and being raised, that issue must be litigated first or resolved first prior to the forcible detainer action.
Great, thank you very much for your argument. Plaintiff waive rebuttal argument?
Yes, Your Honor.
The court will take the matter under submission and notify you of my decision in writing. Thank you, everyone, the plaintiff and the defendants, for being here today, for being available, for your testimony and contributions. I will notify you in writing of my decision.
Thank
Be
you.
safe and have a good holiday season.
Thank you, Your Honor.
What about the video? Sorry, thank you, sir.
That concludes the matter. We are in recess. I will make my decision based on the evidence submitted. Thank you. Have a nice day, everyone.
Thank you, Your Honor.
We're in recess.